Hello, everyone, and a very warm welcome to all of you. We are now in 22, and this is the very first session of the important legal current affairs or legal news for the first 2 weeks of January. Now, in today's session, we will be talking about some important judgments, some bills and acts, as well as any important developments that have taken place in the legal field in the country in the first 15 days of January 2022. I am Jodhpreet, law expert at HitBullsEye, and now let us quickly begin with today's session. Starting with, we are going to start with the court judgments and orders that have happened or that have come in the first 2 weeks of this year. Starting with, let's talk about Maharashtra State Road Transport Corporation versus Dilip Uttam Jayabhai. Now, in this case, what basically has happened is the question came up in case whether an acquittal, that is relieving a person of his charges and having proof that he has not done any criminal wrong. Now, in this perspective, whether an acquittal in a criminal trial will have any sort of bearing or an effect on the disciplinary proceeding against him. Let's first understand what is the difference between the two. One is coming from a legal suit or a legal case, and that is what we are going to be calling as a criminal trial. And on the other end, we have a disciplinary proceeding that is basically a departmental inquiry. That is, the department of this personnel that had employed this person will now conduct an inquiry against him in the respect of his misconduct. That is a disciplinary proceeding. Now, the question came before the court is whether an acquittal in the criminal trial would also lead or would it actually have any impact on the departmental inquiry that is conducted from the department of this person. Now, in this case, what had happened was there was a case of contributory negligence. That is the driver that was appointed in this company and another person, they were both now in an accident of a certain cause and both of the parties were negligent. Now, given that contributory negligence in India states that you will not get any relief and you will not be liable for any compensation, here basically the Supreme Court had absolved any charges against this person, so he was acquitted. But what had happened was, on the basis of the ground that he was in fact negligent and also the fact that there was misconduct on his part, this person was now, in this case, he was in the departmental proceedings, he was removed from his position. Now, over here, when this was challenged, the Supreme Court has clearly stated that an acquittal in a criminal trial has no bearing or it will have no impact on the departmental inquiry. अगर आपको एक केस में acquittal मिल भी जाता है, even then in that circumstance, departmental proceeding में आपको फिर भी liable hold करा जा सकता है and आपके against action लिया जा सकता है. This is what came out of this case. Moving next to the next case, we are going to be talking about State of UP versus McDowell and Company Limited. Now, McDowell Company is a liquor-based brand. Now, the question that came up in this case was whether a fire that took place within the organization or within the company premises, will that amount to act of God or not? Supreme Court has noted that if the fire has come from an external source, then yes, we will count that as an act of God. But अगर आपकी कंपनी में कोई किसी एस्पेक्ट में कोई फॉल्ट थी एंड उसके अकॉर्डिंगली एक वहां पे फायर हुई, फिर एक्ट ऑफ गॉड नहीं कहलाया जाएगा अंडर द लॉ ऑफ टॉर्ट्स. Now, please understand, another thing that you have to remember is act of God का मतलब specifically ये है कि there is involvement of natural forces. Also referred to as nature. Now, जब तक nature नहीं involve होगा किसी aspect में, वहां पे act of God नहीं होगा. So act of God के लिए एक specific criteria that is very important is that there is involvement of the real nature. This is your second case. Now, in this case, there was a fire in the company premises, due to which there was a huge loss that had been incurred in the company's name. When there was an inquiry conducted, it was found out that the fire was in fact a result of an electric short circuit in the company. So that is why in this case it was clearly stated that it will not be included within act of God, simply because nature की involvement नहीं थी. Moving to the next judgment, we have Ram Ratan versus State of MP. Now, in this case, basically section 397 of IPC came into question again. Now, section 397 of IPC talks about the concept of robbery. The question that came up before the court was whether the actual usage of force is necessary for proving the guilt under robbery. क्या अगर कोई सिर्फ एक गन, रिवॉल्वर या फिर एक नाइफ और एनी सच इंडेंजरिंग सब्सटेंस को बस शो करके धमका रहा है, डरा रहा है, इज कॉजिंग फियर इन द माइंड ऑफ द अदर पर्सन, can that also be included within the definition of robbery? The Supreme Court has finally answered. Now over here the Supreme Court has said that the use of weapon does not require that the offender, that is the wrongdoer, shall actually fire or stab. जरूरी नहीं है कि एक्चुअली में फायर हुआ था या फिर एक स्टैब है. Mere exhibition, that is the display of a certain thing or brandishing of that same, is sufficient to bring a person under liability under section 397 of IPC. Now this has been reiterated in this judgment of the Supreme Court कि जरूरी नहीं है कि आपने उस weapon को actually use किया था, बस आपने उसे use किया ताकि दूसरे के सामने there is a threat or a fear, then yes, section 397 can apply. Now, in the next one, we have Gaya by Digambar Puri versus Executive Engineer. Now, what happens in this case is basically the concept is that if a person is deprived of possession of his property on account of acquisition of land. Now, we all understand that under your constitution, Article 31 was deleted in the year 1978, which was your fundamental freedom of property. Eventually, we had another article added into the constitution that states that today your right to own land is absolutely valid. You're given a legal constitutional right. However, you may be deprived only in case where there is a statutory authority involved. So, where through law your land is being taken away, that is valid now, which was earlier had faced a lot of struggle when it was a fundamental right, Article 300A. अब what is the furtherance of this is कि अगर आपका land किसी ने acquire किया है, your land has been acquired by the legal authority, by the government, then in that case you have to understand that जैसे ही आपका लैंड एक्वायर हुआ, it is immediately required that you should be paid compensation for the same. So you will not, the concept where your compensation will come after a long time period has absolutely been done away with. It is mandatory now that the day that there is acquisition of land, immediately after that you will be given compensation. This is what was held in this judgment of the Supreme Court. Now, if the same is not paid to him forthwith, he would be entitled to interest on that compensation. अगर आपने delay किया compensation देने में, फिर आपको additional interest देना पड़ेगा on that compensation. This is the second thing that has come out of this judgment. Now, on the compensation amount from the date of taking possession of the land till the date of payment. So, जब तक आपने final payment नहीं की, आपको सारी duration के लिए you will have to ensure that you give an interest along with the actual compensation. Now, moving to next, we have Jasdeep Singh Jassu versus State of Panjab. Now, over here, section 34 of IPC came into question. So what really is in question here is the concept of common intention versus the concept of similar intention. Now, before I tell you what really was held in this judgment, I'd like to talk about what exactly is common intention. Now, common intention, the concept has been laid down under section 34 of IPC, which clearly states that acts done by several persons in furtherance, that is to further the actual intent of the set of people of common intention. So, let's read the wording once and then I'll try to explain this to you with an example. This section clearly states that when a criminal act is done, again, please remember it must be done by several persons. It will never be applicable in case of only one. So, minimum number, that is two or more. Now, in this case, now where a criminal act is done by several persons in furtherance of the common intention. Now, common intention is a cumulative plan that is going to be there between these two or more people. Now, each of such persons will be liable for that act in the same manner as if it was done by him alone. So, for example, A, B, and C, they sit down one day and they create a plan. The plan is to commit robbery and robbery on a bank. So they three decide, all right, let us plan. A says, okay, I will now ensure that I drive you up until the, to the bank. So A says, I will drive you to the bank. B purchases the gun that was planned amongst these three individuals. And then C and B, they together go inside the bank. मतलब एक गाड़ी में तीनों को लेके गया. Then after that बैंक के बाहर पार्क करके रखी गाड़ी. Then B and C they went inside, they robbed. उसके अंदर जाके let's say किसी की डेथ हो गई. So now they come out running and they flee. Common intention rule says here A, B and C will equally be liable for the offense of robbery as well as of murder exclusively. चाहे A बाहर बैठा था, but he was actively, acting in the furtherance, that is in the fulfillment of, taking steps towards the fulfillment of a common goal, that was to complete that robbery. वहां पे इन तीनों को इक्वल पनिशमेंट मिलेगी, चाहे ए बाहर खड़ा था, चाहे गोली सिर्फ सी ने चलाई थी, does not matter. This is what is the rule of common intention laid down in section 34 of IPC. The question now comes in, what if A and B had never really planned on carrying a gun, but C ने इन दोनों को बिना बताए एक गन लेके गया? Should A and B also be held liable for the act of C in this case? The answer is no, because this now comes out to become similar intention. Here A and B did not have any intention of carrying the gun into those premises. So to hold those people equally liable for the act committed by C would be a wrongdoing and would not be justified in the eyes of law. Because here in this case, this furtherance has not come. That is what came into the question in this basic case. A gun was being carried by one individual, but the other two were not aware of this. So what has the Supreme Court laid down in this case? Now, Supreme Court has stated that a mere common intention per se may not attract Section 34 until and unless there is furtherance in that regard. Now, the Supreme Court observed that here, if only there we can prove that there were steps taken in furtherance of a common intention or a common objective, a common plan amongst these individuals, then yes, we can hold all of them liable, otherwise no. Moving to the next judgment. The next judgment is Mahendra versus State of MP again. Now over here, in this case, Section 149 of IPC came into question. So what I was just talking about was the concept of common intention and similar intention. Now I move on to the concept of common object. Now here basically, if I want to hold any person liable under common object given under section 149, we have to look into the correlation of section 141 of IPC. which is unlawful assembly. Now, Section 141 clearly lays down that we can declare an assembly as unlawful if and only if we have minimum of 5 persons present in that assembly. So, if there is even 4 people, we cannot apply a common object. So, here again, this concept came up before the court. The question comes up that let's say, for example, there were 7 people in the assembly proceeding a unlawful purpose as under section 141. Now let's say out of these 7, only 3 were caught by the police. Out of the 7, now 4 are still missing. What will the law say in this situation? Are we going to still apply this rule as it is, or are we going to give it an elaborate illustration in this regard? Let's see what the Supreme Court has stated in this regard. Now, Supreme Court reiterated that it is an essential condition of an unlawful assembly that its membership must be minimum of 5. So, 5 or more. Now, it is essential, further stated by the Supreme Court, it is essential condition of an unlawful assembly that its members must be 5 or more, as given under section 141. At the same time, it is or it may not be necessary that 5 or more persons will necessarily be brought before the court or be convicted. Because in this case, let's say 4 fled the scene and only 3 were caught. Now here, if less than 5 persons are to be charged with section 149, then there has to be a situation that has to prove that the case before the court and the numbering in all should be more than 5 composed of an unlawful assembly. You have to clearly enforce and prove that there were in fact more than 5 members that were actually a part of this assembly, and these others being persons not identified or unarmed. So we could not identify in this situation the rest of the 4 members. Once we can prove that, yes, then we can proceed in charging these 3 with unlawful assembly read with common object. So this is what was held in this case by the Supreme Court. Moving to next, we have Sukriti and others versus CBSE and others. Now basically the question in this case that came up was the concept of having improvement exams. Now students who have appeared for the class 12 exam, they have an option to appear for improvement exams. Now, up until some time back, what used to happen was there being an improvement chance given, the higher score from the actual score or the improvement score, whichever used to be higher used to be considered. But in clause 28 of CBSE policy that had come in recently, it was stated that we will consider only the improvement score as final and we will not give any consideration to the actual score. So no higher score amongst these will be looked into. The Supreme Court has clarified and stated that this will not be allowed. They have absolutely quashed the CBSE policy in this regard, and they have said that the better of 2 options to the students must prevail. This is what came out of this judgment. The bench further directed the CBSE shall provide the option to the candidate to accept the better of the 2 marks. It would be derogatory and not correct, unjustified if we said that we are only going to look at this score when earlier we used to give them a choice between whichever is the better score. So, इसीलिए this has been struck down and quashed by the Supreme Court. Moving ahead, State of MP versus Jogendra. Now, in this case, basically the concept of dowry was questioned. We've had some judgments in the past regarding Section 304B of the Indian Penal Code, where we have discussed that now soon before cannot be counted as immediately before, which was a rather landmark judgment which elaborated the scope of Section 304B dowry debt under your IPC. So now what exactly is the next step that the Supreme Court is taking? They're trying to elaborate the scope of dowry. Now over here, the Supreme Court has observed that the demand of money for the construction of a house will also be included within dowry demand. So elaborating the scope and the definition of dowry, now it will also include demand for the money for the construction of a house. So now, what is the purpose behind it? The purpose being clearly stated that we want to give a elaborate perspective. We want to ascribe and expand the scope of dowry as given under the law. So now, moving ahead from here, we are going to talk about the important bills and acts that have come in the last 2 weeks. Quickly starting with the first is the Delhi Teachers University Bill. Let us quickly just go through the facts of this bill. It is a landmark bill for the Delhi Assembly. Now, the Delhi Teachers University Bill was passed by the Delhi Assembly on January 4, 2022. What is the purpose? It seeks to set up a teachers training university in Delhi. So what is the agenda about, setting up a university for the teachers? The agenda is basically that you want to offer quality education. And quality education comes by actually training and intensively training the teachers. So the university will offer a 4-year integrated teacher education program after class 12, and it will be a public university, will be dedicated to prepare excellent quality teachers for Delhi across different school stages. So this is what is this bill targeting and it's aimed at. Moving next, we have some extended producer responsibility of waste tires. Now, this is a draft notification that has come in respect of extending producer responsibility and covering the concept of waste tires. Now, in a report and in a case before the NGT, that is the National Green Tribunal, there came the horrifying scene where the waste tire management of the country was brought about. So now on September 19, 2019, NGT had subsequent to that case directed the Central Pollution Control Board CPCB to draft a comprehensive waste management plan for waste tires and their recycling. So major task is the amount of carbon emissions that come after we have now, after importing a lot of waste tires in the country, after they have been recycled, there is an extensive amount of carbon emissions that come and now are harmful for the environment. So this is a major step in development in this regard. Now, NGT directed that in a case related to the absence of proper management of end-of-life tires or waste tires, please remember we're not talking about the new ones, we're talking about when the life of the tire comes to an end. It's recycling. What will be the actual responsibility of the producer now is going to be coming into question. So now, on the 5th of January 2022, Ministry of Environment, Forest and Climate Change shared the draft notification for regulations of EPR for waste tires. Now, EPR basically is what? What is EPR? Because we are discussing the concept. Now, what is this liability that we are going to be discussing? Now, EPR basically is the responsibility of the producer of the tires. Now, they are going to be entitled to ensure environmentally sound management of such tires in accordance with the provisions of this new regulation. So, this is completely now going to become the responsibility of the first producer of the tires to eventually be liable for the consequences that come off from their recycling. Moving ahead, let's talk about the important events, days, and appointments that are coming in the last 2 weeks. We're going to quickly brush through. Number one, a controversial perspective, that is Sushmita Dev is a part of a 31-member panel that will look into the bill that would raise the legal age of marriage. Now, just some time back, we had the news that, had been it had spread rapidly across the country. That was now finally, the legal age of marriage of women was going to be raised from 18 to 21. Now, as a consequence of this, the 31-member panel has been set up to actually look into its impact on the Prohibition of Child Marriage Act 2006. Now, please understand that the Prohibition of Child Marriage Act also has an effect on a lot of other laws, which are the Indian Christian Marriage Act, the Parsi Marriage and Divorce Act, Muslim Personal Law, that is the Shariat Application Act, the Special Marriage Act. We're going to be discussing the Hindu Marriage Act, the Foreign Marriage Act, all of these. These are all going to be impacted by the change of the age of the girl in this act, that is the Prohibition of Child Marriage Amendment Bill 2021. Now, why was there a controversy in this regard is because in this 31 member panel, there is only one woman. Hence, a lot of controversy has come up and there is a lot of criticism in this case because 31 members now looking towards the increase of age of the girl from 18 to 21, which has a correlative aspect on so many laws, and there is only one woman that is there on this panel. Naturally, we are looking for more women to come in and give their input in this panel. That is why there was a controversy in this regard. Moving next, Ganjam in Odisha has declared itself the first child marriage free district in the state of Odisha. Very important, that is what is the name of the district that has declared itself free from child marriage in the state of Odisha. Moving ahead, we're talking about next, the Supreme Court of India has allowed the commencement of counselling process of NEET, that is NEET PG, as well as UG for the academic year of 21 and 22, which was on hold for quite some time in regards of the reservation aspects. Now, it is going to be going ahead with the existing quota system and the constitutional validity of the 27% OBC reservation was upheld in this case. The changes of your various committees will now come up in the next session. Moving ahead, CryptoWire, a global crypto super app and a ticker plant special business unit announced the launch of India's first cryptocurrency index, that is IC15. So IC15, that is your first cryptocurrency index that will look into the top 15 cryptocurrencies in India. This is an important aspect because very not long ago the government was again talking about banning cryptocurrencies. However, then they moved to regulating cryptocurrencies and now we have India's first ever cryptocurrency index. So try to keep up with the cryptocurrency news and updates that you keep getting from time to time. Moving next, the Prime Minister on 9th of December 2022 had stated that December 26th shall be observed as Veer Bal Divas in the honor of Mughals executions of the 10th Sikh Gurus Guru Gobind Singh Ji's 4 sons. So this is now another important date that has been added to the list that we have been continuing. Moving to last, talking about the international perspective, the Canadian government has officially implemented a ban on conversion therapy. Now, please remember, last year we had a judgment that had come up from the Madras High Court that had talked about the government must take steps to ban your conversion therapy in India. We are still looking towards it. We may implement it sometime on, but here we have the Canadian government that has implemented a ban on conversion therapy. Now, the bill, what is it going to provide? The bill has made providing, promoting, advertising the conversion therapy a criminal offense. It will now be illegal to promote, advertise, benefit from, or subject someone to harmful or hateful because of the rights of LGBTQ community. Now, why is this done? Because the human rights of individuals came into question. But what is this conversion that we are trying to discuss over here? Now, the conversion therapies are based on the belief that sexual orientation can be cured or changed. This practice is often performed by certain religious leaders However, some licensed clinicians are also involved in this practice. But it is considered in today's time, and given that under section 377 now was done away with under your IPC after the Navdeep Singh Johar judgment, naturally this question has now come up in India as well. Now, beyond Canada, Brazil, Germany, Ecuador, and Malta has also banned this practice. Argentina, Samoa, Uruguay, Fiji, and Nora have banned this practice indirectly. And US, Australia, and Spain have now, within certain areas of their countries, have banned this practice. Not wholly, but yes, naturally, some areas it has been banned. So, this is something where we need a law. This is an area where law is required in the future, and probably, positively, we can hope for the same in the future. Now that is all for today. For more such news and such videos, you can subscribe to our channel on YouTube, HitBullsEye. Thank you.